reporting, and the new standard in taking medical control is we have to show denial of medical care. And if there's one thing I want you to leave this little program with, and I think the most important thing is if you don't have a paper trail in your file to justify if you don't have a paper trail in your file to justify why you're treating this patient, or a paper trail to justify the need for a MedLegal report, you're dead. And one thing I hear from the doctors all the time, and it makes no sense to me at all, is that, well, I keep on asking the attorney and they don't respond, they won't do this, they won't go in for AOE to prove that the injury is industrial and all this stuff. They don't send me a letter for MedLegal reporting. They don't tell me why we're treating out of the MPN. And my feeling is, why the hell are you taking these cases? I mean, and the doctors always come back to me and they say, well, I don't want to make them mad, because if I make them mad, they're not going to send me any more cases anymore. And I ask them, why do you want to work for nothing? Because basically that's what you're doing, is you're working for nothing. Under the new guidelines and the systems, you have an administration that is disgusted with liens. Okay? When I was president in 2010, 2011, I met with Christine Baker on numerous occasions. She's the EIR Director of Industrial Relations. And all she kept on throwing at me was, these doctors in the South abusing the system, and look at these liens building up. Thousands upon thousands, hundreds of thousands of liens building up. And I said to Christine, Christine, you're not being fair. I said, number one, you have two labor code sections, 4603, which talks about treatment and billing and what you get paid for and when you should get paid. Okay? And you have 4622 to 4625 on MedLegal, which tells you the same thing. Gentlemen, you want to come on in, find a seat, sure, and make sure you have, this should be three things for you. Okay? Ricky, can you make sure that they have all three? There's an extra one too. Okay. So I'm telling Christine, I said, it wasn't the doctors, it's the system. You got insurance companies that just stopped paying the doctors, and thanks to Schwarzenegger virtually eliminating penalties, when he changed the penalties from 10 or 15% to 25% or $10,000, whichever was less, it just, and he took away the penalties on the entire class of benefits. It used to be that if I went in for a 10% penalty, and there were $50,000 in medical that have already been billed on this particular case, I would get 10% of that $50,000. I get $5,000 penalty every time I went in, even if it was over a $75 prescription charge. When he changed it, if I go in over a $75 prescription charge, I can get 25% of that $75. What attorneys can do that? None of them will. None of the attorneys in this room. Oh, by the way, I'm very into that. I don't know. I'm sorry I didn't introduce myself. But okay, so that was problem number one. Schwarzenegger eliminated penalties, virtually eliminated penalties. Before that, we had judges that weren't awarding the penalties or interest or any of those things before. Okay, and then all of a sudden you got then the second whammy is we get to court. And I'm standing there at trial, and Chuck, all those other guys over there, the same. We're at trial. You have a representative there. The other lien claimants have a representative there. The applicant is there, and we're there. Okay, we're ready to go forward. We couldn't settle the case. We're ready to go forward. The first thing the judges did was say, you know something, let's just try the case in chief for the applicant, and we'll do the liens later. And they bifurcated the liens. And basically what they did is they kicked the can down the road. So, and it put you at a tremendous disadvantage, because once the can was kicked down the road, and we go to trial on the case, or we settle the case, you're off calendar. You have to go back on calendar to prove up your case, and then you had to prove that the injury was industrial. And you know, attorneys virtually allow any language in a compromise and release. And a lot of times the language in a compromise and release screws the doctors. And the excuse the attorneys will give is that, well, my first duty is to the client. And if they want to put Thomas type of language in there and they throw in an extra $5,000 to my client, my duty's to them. And they're being very short-sighted because they're putting the doctors out of the business. And you can't do that. And in fact, in the paperwork that I gave you at the end, I even gave you a sample CNR with typical damaging. This actually came into our office asking us to sign it, which we didn't sign it. We modified and changed it. But I gave you a copy of it to look at the language in there. They're saying it's a post-termination case. Okay? So they want to have a post-termination defense on it so they can screw the doctors on the lien. But yet the last document, they're asking him to sign a resignation. Now, how could it be a post-termination case if they're asking him to sign a resignation? If he signed the resignation, it means he's still working there. So if he's still working there, it's not post-termination. But that's the typical stuff that we would get. And your lien representatives would go to court, and they would be thrown these curves on. You know, first of all, you've got to tell your people in your office, don't believe any crap that the adjusters say to your collectors. They have been taught to say anything, and you guys, most cases, don't have a comeback for it. You have to have your people say, what is the authority for that position you're taking? Authority could either be a regulation, it could be a labor code, or it could be a case, some case law. And if they can't produce that, they have no authority. So you've got to call their bluff on a lot of these things. In fact, if you have the authority, and between the cases that we gave you in these 3 packages and the labor code sections, there's a lot of authority to support your position if you do it right and if the attorney does it right with you. Okay? But more than not, you have to have a working arrangement and communication totally open with your attorneys. If you don't, you're dead in the water. If Michael has a problem in my office, he'll call me on the phone. He'll say, Barry, I need this and that, and we do our best to do it. Do we do it every time, Michael? No. But at least we have that dialogue, and you have to have that ability to do it. If you're getting cases from an attorney who is not agreeing to dialogue with you or responding to you, don't take those cases. You're working for nothing, and that's the bottom line. Okay, so in the packet, and I'm sorry the packet does not have, it's really for your review, but I wanted to go over some things and talk about MedLegal. Okay. Everybody wants to do a MedLegal report, and I think it's important that we set it up properly so that you do a MedLegal report. So doctors' first reports, and we've changed our policy in the office. 8 months ago, we were basically asking the doctors for some type of a comprehensive. And I know Telleria's firm has been asking for a comprehensive. Okay, we've changed our policy on that, and I think all attorneys need to change their policy. First of all, the doctors don't get paid for a comprehensive report up front. And secondly, if you put too much in that report, you may be precluding your ability later down the road to get a MedLegal report. Because if you're writing a thorough report that addresses causation, and then they deny the injury based upon causation, how do you then get a MedLegal rebuttal to that report when you've already addressed the issue of causation? Obviously, you need to say it's industrial, but you don't have to go into too many details. In your doctor's first report, put your treatment schedule in there, your recommendations, put the body parts, the basic complaints, the date of the injury, and those types of things in there. It's a one-page little report.
That's what you do.
Okay, and then you just say it's industrial. That's all you have to do. You don't have to go into detail on it. Okay. The basic rule is that, and Chuck, correct me if I'm wrong, is you can't do a MedLegal in the first 60 days unless the case has been denied. Okay. In many cases, we don't get a denial until the 85th or 89th day. And the labor code is really clear, though. there's an absolute obligation on the part of the insurance company. Let me just read this to you. This is the regulation 9767.6, and it's not in your package, but write the thing down.
What was it?
9767.6. It's titled Treatment and Change of Physicians Within the NPN. Okay. Under subsection C, little c in parentheses, the employer or insurer shall, and shall in the labor code means must. Unfortunately, the Court of Appeals doesn't always, agree with that, even though they say it, that's what it is, they don't always enforce it. Employer or insurer shall provide for treatment with NPN providers for the alleged injury, and shall continue to provide treatment until the date that liability for the claim is rejected. So basically, if they have an NPN and a claim form is sent in by one of the attorneys, or the person just reports the injury at work and the claim form goes in through their HR department, they have an absolute obligation to pick up treatment forthwith, right from day one. Okay? And we have cases under 4610, 4616. They talk about, the first appointment has to be within 3 working days, and the injured worker shall go to it. And we have the Sanhagen case that supports, that's on UR, and we have the case on the 3 and the 5 day night. The night decision is still very good law that says within 3 working days to set up the first appointment, and the first appointment has to be set up within 24 hours, but to take place within 3 working days. But we've had a number of cases that sort of cut some legs out of Knight. Knight was an in-bank decision, and a very important in-bank decision, and it gave us the opportunity to take medical control when the insurance companies weren't providing control within the NPM. And a number of cases came back out since Knight, which sort of cut the legs out a little of Knight, saying is that if the defect was curable, so they didn't get it within the 3 days, working days. It was, a week later. Was that enough to justify being out of the NPN? And a lot of those cases said no. Okay. Unless we could show the fact is because they didn't set up medical care, they didn't take medical control, they weren't providing the care, did it result in a denial of medical care? And that's something that the doctor really needs to be able to address, is if you're taking medical control up front when you know that the company has an NPN and they have not set up any medical. Okay. So, we talked about the doctors first. Okay, now every 45 days, and you have 5 working days to get that report out. You get paid for nothing that takes place until that report goes out. Okay, so if you do diagnostic studies in your office, any other types of testing and all that stuff, and you don't get the report to them until, let's say, day 15, and on day 5 or 6 is when you did those studies, you don't get paid for that. Right, Lance?
Correct.
Correct. You're just giving it away, so you have to get your offices in tune to make sure that those initial reports get out on a timely basis. And that's why getting involved in big comprehensive reports is counterproductive anyway, so you don't want to do that. Okay. So, what we want now is we want to set it up so that you can get your MedLegal report. I think it's important. The basic MedLegal report, I think, is $625. Okay, and you also can get review of records and everything else. You hear from them saying is that, well, under Medicare you don't get paid for review of records. But if you look at this, okay.
It has to be face-to-face?
Under 4620, I'm going to go through some basic definitions. 4620, for the purpose of this article, 4620 is your Bible for MedLegal. 4620 at SEC, all the way to 4628, which is the one that requires you to sign your reports on the penalty of perjury, and advise names of anybody who contributed to the report or any of the treatment or any of the examination. Okay. Purpose of this article: a MedLegal expense means any cost and expense incurred by or on behalf of any party, the administrative director or the board, where expenses may include x-rays, lab fees, other diagnostic tests, medical reports, medical records, medical testimony, and as needed interpreter's fees. Okay. A contested claim exists when the employer knows or reasonably should know that the employee is claiming entitlement to any benefit arising out of a claimed injury, and one of the following exists. Number one, the employer rejects liability for the claimed benefit. Number two, the employer fails to accept liability benefits after the expiration of a reasonable time period, which to decide, that's the 90 days. They got 90 days to either admit or deny the claim. They don't have to do anything to admit the claim. They have to do something affirmative to deny the claim. There has to be something in writing to deny it. When 90 days come and if they haven't denied the claim, it's presumed to be compensable. Okay. The employer fails to respond to a demand for payment of benefits after the expiration of any time period fixed by statute. The law says within 14 days of them being advised of an injury, they're supposed to pick up temporary disability benefits for the injured worker unless they delay the case. And the delay technically has to be within that 14-day period. We rarely see it. It's usually not done timely. Costs of medical evaluation, diagnostic tests, and interpreters incidental to the production of a medical report do not constitute a med-legal expense unless the medical report is capable of proving or disproving a disputed medical fact. That is the definition of med-legal. The determination of which is essential for the adjudication of the employee's claim for benefits. In determining, and this is where your med record review comes in determining whether a report meets the requirements of the subdivision, a judge shall give full consideration to the substance as well as the form of the report. Substance is whether it meets the substantial evidence test. If you didn't review medical records, how is your report substantial evidence? I don't know. I think it doesn't. I think it fails. And if they're giving a directive right in the labor code for the judge as a requirement, shall give full consideration as to the substance as well as the form. So obviously you'd have to do the proper form, the format. You're going to have to justify, and you're going to have to indicate what the contest is. And you want medical records and review those records. So you got a minimum $625 plus the time in reviewing records. Chuck, am I still right on?
Yeah.
Okay, good. See, you're talking well. See? Okay. Okay, and I already told you that, and also under 4621, it makes it very clear, no med-legal reports within the first 60 days unless the case is denied, the claim is denied. Okay. Somebody...
Excuse me.
Yes, go ahead.
Can you do a med-legal even if a case is not denied after 60 days? You can do a med-legal?
Yes, but how do you do med-legal?
Unless you get a denial.
Okay, so you get a denial. Okay? You got a denial on the 61st day.
Right.
Okay. What do you need to do to get a med-legal?
A letter from the attorney.
Paper trail, that's your paper trail.
Requesting med-legal.
Okay, only an applicant's attorney or the claims administrator, according to the labor code, can request a med-legal, or the judge. Judge could request a med-legal reporting too. Can you have more than one med-legal report? Yeah, I think you can.
Not anymore.
Why?
MedLegal only from a treating doctor. You can have a MedLegal, or you can have a follow-up MedLegal report. And a PNS could be a MedLegal if the case denied.
Well, PNS could be a MedLegal, but it's
Right.
just, okay, misnomer. A lot of doctors feel that because you're doing a PNS report, it's automatically a MedLegal. It's not. It's not. You still have to have that letter from the applicant's attorney advising you of the dispute that give rise to the need for proving and disproving a disputed medical fact. And I think we can even say not only medical fact, but even legal fact. Okay, yes?
Can the doctor, as an advocate for the patient, explaining the situation, have the patient disclose in writing that I want you as the doctor to issue a report that medically and legally disputes what the insurance has refuted?
Is he represented?
Yes.
No.
Only the attorney.
No. You know, a lot of doctors did that because they're not getting cooperation from the attorneys to get the patient to do that. You know, I mean, the judges look right through that. They say they know what's going on, that the doctor just, you know, they'll, if the judge asks the applicant in cross-examination or his own questioning in the time of a trial, you know, what does the
You have
applicant
got only one or two MedLegal candidates.
Requested.
Huh?
Requested.
So I think it's a dangerous move to do it. Again, if you're not getting cooperation from the attorney, it shouldn't be there. Question is if an insurance company denies the injury, will a non-MPN doctor actually accept the applicant and treat him or her? Why not?
That's the only time you would.
I think that's where you want to go.
Repeat the question.
Because clearly you
Repeat.
could show, and you should show in your initial report the denial. of
Repeat
medical care.
the question.
Repeat the question.
Yes,
for the-
please.
For the camera, okay. If an insurance company denies the injury, will a non-MPN doctor actually accept the applicant and treat him or her?
Of course, yes.
Yeah.
That's the best of it.
You know, it's amazing, I get questions, and first of all, there is no bad question, and there's no stupid questions, I want you to understand it. This is legal stuff, okay? We have some attorneys here in the room, but we're not all attorneys. Just like if it was a medical question, we're not all medical doctors. Yes, go ahead.
So Barry, I think the question more, if you just take a non out of the question, non-MPN doctor, then it becomes an interesting question. Because if the claim is denied, should an MPN doctor of that insurance company take that case?
Okay, that's a different question, okay.
Shouldn't be.
So let's rephrase that.
If
Okay,
you're
so
empty.
we have a dispute raised by the employer or the insurance company denying the case. Okay, let's say, under that regulation that I read to you before, 9767-6 or whatever it was, they picked up treatment as soon as they got the claim form. And later down the road, they denied the injury. Okay, maybe their own doctor may have come back and said, I don't think there's industrial causations, and that might have been grounds for them to, see, insurance companies are basically stupid. I'm sorry, they're stupid. If I was an insurance company, I would pick up benefit, I would pick up treatment on every claim form. Okay. Everybody following it so far? Okay, so Chuck, you want to add any of this so far?
Doing fine.
Oh, really?
Doing fine.
Okay. I want to bring to you, and this is actually something that Chuck brought to my attention, a relatively new regulation, and you have it in your packet. It's 104.51.1. It's extremely important, and it's amazing how people don't know about it. There was a treatise just written in Comments. Comments is a magazine that COP puts out. Okay, and one of our past presidents and probably one of the brightest of all the attorneys in the system wrote this letter on MedLegal. And he went into 4620, 4621, all these labor code sections and some regulations, never mentioned 104.51.1. So I brought it to his attention, and I gave him one of these packets actually, and he looked at it, and he was shocked. Okay, this is relatively new, okay? And this was for injuries, I think, after 1/113?
1/113.
Yeah.
There's no way to apply it to cases before 1/113. You can talk about IMR and IBR, and they don't exist prior to 1/113.
Right. Okay, so determination of medical legal disputes, expense disputes. The following procedures shall be utilized for the determination of a med-legal dispute. Med-legal, first of all, they define it. Med-legal shall mean any cost or expense incurred by or on behalf of any party for the purpose of proving or disproving a contested claim, including but not limited to the following: goods for service or services expressly specified under 4620, services rendered by non-medical expert witness, services rendered by a certified interpreter in a med-legal evaluation or examination, all costs or expenses for copying and related services. Med-legal provider shall mean any person or entity that seeks payment for reimbursement of a med-legal expense other than an employee, independent, or an attorney or non-attorney representative of the employee. Okay. Okay, so med-legal expenses, most med-legal expense disputes are not subject to independent bill review. Some of them are, but for the most part, it's not. Okay, so if you're billing for fee schedule, the general rule is that it's not subject to IBR. Also, according to this provision here, a med-legal provider is not required to file a lien. Under no circumstances do you want to file a lien. As soon as you file a lien, number one, you got your filing fee. It was $150 now? $150 filing fee. And then, once a lien is filed, it's a different level of citizenship. Okay. You technically, if they don't pay within 60 days, I think it's 60 days?
Petition.
60 days of each
Med-legal.
med-legal, billing. There's an automatic 10% added on and 7% interest from the date they receive that bill, if they don't pay. Also, this regulation gives authority for a med-legal provider to actually file a declaration of readiness to proceed prior to the case in chief being resolved. Can't do that if you're a lien claimant. Nobody's going to see it, but you can. And why can you do that? Because there's a provision with the same regulation. It's called bad faith actions or tactics. If a workers' compensation appeals board determines that as a result of bad faith actions or tactics, a defendant failed to comply with the requirements, timelines, and procedures set forth in 4622, that's payment, okay? Or 4603.3, that's interesting, that's for treatment, but that's interesting.
That's the EOB.
EOB, okay? And the defendant shall be liable for med-legal providers' reasonable attorney's fees and costs. Whoa. Wow, Lance likes that one. Right? That's why he's wearing this green. Okay. If any, and for sanctions under 5813. 5813 is sanctions for unreasonable delay. This is different than 5814. This is one you could show, and Rule 10561. The amount of attorney's fees, costs, and sanctions payable shall be determined by the Workers' Compensation Appeals Board. However, a bad faith action or tactic occurring on or after the effective date of this section, the monetary sanctions shall not be less than $500. That's just the sanctions, plus the attorney's fees on top of it. Okay. Chuck, do you think they have to have a separate attorney to do it, or can the applicant's attorney file the DOR and go in on behalf of the doctor? We know that we used to have regulation that as applicant's attorneys, if the doctor didn't show up at trial, we could try their aspect of the case before they were kicking all the cans down the road. We can go in and we actually would get a 15% fee of the doctor's bill. So, what do you think about that?
I think if your client consents and there's no conflict, well, I can't see why not.
Well, we're helping the client out too. We could explain to the client, it's keeping the doctor willing to keep treating and taking care of them.
Well,
And
not just to keep treating, but to enforce the right to the completion of the MedLegal. Because even, not just treating MedLegals these days, but even PQME MedLegal providers are resisting and refusing to issue supplemental reports until they've been paid for the initial report. So by extension of your question, Chuck's logic, you would be enforcing the injured worker's right to the completion of the MedLegal process. Because that is where the resistance is starting to build in the industry, even on the MedLegal side, is the carriers are just thumbing their nose at them and saying, I'm not gonna pay you.
the reality is when you go to court on these, you're gonna have to educate the judges. The judges are clearly not aware of a lot of this stuff. And, and maybe it would be easier to use the applicant's attorney because a lot of the applicant's attorneys now file their DORs through EAMS. We do that in our office now. So it's easy to file a DOR and get a date. Michael, you got a question?
Yeah, I had a question. Do you file a DOR on MedLegal if MedLegal is not paid after 60 days? You have to send them a letter, and then after that you file a DOR or a petition to court it.
No, go ahead.
The technical process, as we discussed before, Michael, is the affirmative action moves to the defendant once you file the objection to the EOR. You file a timely objection with the carrier and or their representative within the statutory time frame. The affirmative burden shifts to the defendant. I have not seen one defendant in now 25 months take the next step in the regulatory process, which is to file a responding petition and file the DOR. That's what 104.51.1 calls for, and 4622C as well. So 104.51.1 in its promulgation lets the adversely affected provider, or the injured worker, a medical legal provider as an extension of their benefit, enforce that resolution of that process. This was one of the changes made in 863 to get the MedLegal resolution payment and entitlement off the back of the bus with the rest of the liens. That's why it moved into a petition. It moved out of the lien classification. There's no classification where there's a mandatory filing for a MedLegal lien any longer. So before you file that DOR, though, you have to establish that you did file that objection to the defense counsel and or the carrier, and then that statutory time frame passed and they did nothing. Because that's what gives rise, I believe, to the 105.61, because the violation of any regulation is in itself de facto sanctionable. So if they don't take that affirmative act, which none of them have, the providers and the representatives have the right to push that MedLegal.
Anyway, so my point actually is that really, we have got to send records from our side. Okay? This is a very complicated process. Just filing the IMR for the attorneys is not enough. If you just file the IMR application, it actually is not enough. If we want to actually help our patients and our clients. Okay? We actually have to carry this over. Now the problem that the attorneys face, the doctors, I'm telling you very, very frankly, is trying to get the doctors to send in records into them so they can send it over to the IMR.
There's a problem before that. The problem before that is what you put in your RFAs. I mean, if you've given a person 5 physical therapists, and now you're asking for another 5 physical therapists, if you don't show any functional improvement, there's no justification for those 5 additional therapies. It's slam dunk, you are an IMR denial.
Well, I can tell you for a fact that he's right. And why do I tell you that? It's because I've actually reviewed more than 10,000 IMR decisions. It's extremely nerdy to do, but I've done it. Right, these are the 4 to 5 pages, and we've actually created a software that can, and if you guys want any you want, we don't charge anything for it. You can have it. But you can actually search for the different modalities that you do. So let's say if you do 10 units in your practice, we can actually give you all the prior IMR decisions that are on the DWC database and bring out for you, give you what reasons does IMR approve and what reasons the IMR declines the request for the TENS units, EMG, MRIs, everything else, right? And chiropractic. And so this is really very, very helpful for you to put in your RFAs if you can actually cite prior IMR decisions. So that's on the site and definitely very, very important point of what Barry's saying. So now we get into this whole idea of sending in medical records. And we can certainly help you, and most of the attorneys already I'm working with in terms of sending in we have a service that we provide. It doesn't cost you anything. So you guys know I'm going to do a little 2-minute, 30-second commercial. You know, I have a company called Vital Imaging, so we do MRIs. So the reason I've put this IMR services department together is because we are completely blind as a tertiary provider, secondary providers. You guys understand that, right, Robin? I mean, think about this. You got somebody who's like Michael's does a request RFA for our MRI. You are denied it. Do you think Michael, as close of friends as we are, ever calls me and says, "Hey, Sana, you are denied the MRI"? Did any of you guys call me? Right? You ever call me? No. My point is, and I'm not blaming you for it. My point is that it's we're flying totally blind. So in order to not flying blind anymore, I've actually been doing the IMR service applications for my doctors and attorneys. So that's one part. I'm going to tell you about something that is the most scariest of this IMR process for me. And it's something called retrospective UR. How many of you are aware of what who's heard of retrospective UR? Okay, who has not heard of retrospective UR? Okay, good, because you went to USC. That's I'm so happy you raised your hand because that proves a point to me. So mean. I'm just kidding. No, I bleed blue. We're on outside. So here's the problem with retrospective UR, and then I got to get going very soon, so I'm going to try to keep this short, and you can carry it afterwards for me, please, or Jeff can.
Sure.
Retrospective UR is a major issue here, right? Because what basically the code says that the insurance company carrier does not have to do UR on denied cases or disputed cases. You guys know that, right? However, the code goes on, and it says that basically the insurance company has the right to do retrospective UR once liability is established. They have 30 days to do retrospective UR once liability is established. So the doctors in this room, think about this for a moment. And this is a question that my friend Lance posed to me, which shocked me a year ago. I don't know why. You shocked me a lot. What happens when the case in chief is settled? Alex? You're done, right? Right? And the patient is done, right? The client is done. And retrospective UR happens on potentially all of the treatment. Robin, are you following this? Right? If retrospective happens now, what is the motivation of your office to do 15 IMR applications on a case that's closed? Are you guys following this? Now, what if the attorney's office does not file 15 IMRs on those retrospective UR denials and 30 days expire? What just happened to my AR and Brian's AR and Michael's AR?
Lost.
Are you guys following the... Now, why am I afraid of this? It's because in November, at the conference in Dana Point, Barry, this is the defense conference, they were actually in front of literally hundreds, if not thousands, people, saying to utilize retrospective UR as a major hammer against lien claimants. So this is coming.
Son, isn't it true that if they're going to do the retrospective UR, they still within the 5 to 14 days have to defer?
Yes. So are we getting records? for them to get ready?
No.
Oh, the 5, they have to.
In other words,
I see.
once your RFA comes out, okay, they have 5 to 14 days under UR to either accept or deny or modify. Okay. If they decide to do the retrospective or delay it for a retrospective UR, they still have to, within the 5 to 14 days, put you on notice that they're intending to delay and do it retrospectively. If they don't, they've blown it.
Is that true? I mean, is that,
Yes.
Yeah.
Is that,
Yes.
is that actually the case? Can
Yes,
Yes.
Chuck, can you look at it for me?
yes.
Yeah.
It's true.
Look,
I haven't seen the case, but the Sanhagen concept, I think by extension, if you don't defer timely, how can you revive the right to perform UR when you didn't start the regulatory process correctly in the first place?
I believe all you guys. I just want to see the code.
Well, that's not the code. I don't have a case on the top of my head that speaks to the proposition, but it would seem like a logical extension of the Sanhagen analysis.
There was something in the 860.
So that's great. If you can look it up for me, that would be great, because then I can actually teach all of my doctors to make sure that they file an RFA on denied cases, because a lot of the doctors don't.
But before we get there, the problem we're seeing in our office is proof of services. Lack
Yes.
thereof.
Yes.
You know, I mean, before we could even go anywhere, I have to know when you served your RFA to the insurance company.
And how it was served.
And a lot of the times now, if you happen to be in the MPN, they're insisting that you do it by fax. And we're not getting the confirmations. So I have no idea. So I have nothing to take to court to prove to a judge that the UR denial was not timely.
Send the proof of
Okay, so,
service.
yeah, so we'll actually, as we go forward for your office, you're going to be getting that from us. Because what we do is, we actually, when his office receives the UR denial with their IMR application, they actually send it over to us. We actually process that. And the way it works is, we actually take the UR denial date, and this is very important. And when I get the RFA, Michael, from your office, because we have to get the recent records from the doctor's office. You cannot rely on the records you have in your files, because that's probably not what the UR denial is on. Okay? So you take the date of the fax, and we put it in our software, and then actually then matches with the date of the denial. Not when they say they received it on that piece of paper. 70% of the time, maybe higher, they actually are incorrect in when they say they received the RFA. You gotta go by I don't care about when they say they received it, it has to go by the faxed date on the doctor's RFA. Okay?
Because there's a delay between when the adjuster finally sends it through the route to SID management or whatever it is that.
We even keep the envelope. If it's late,
I
we
actually
keep the
think-
envelope.
I actually think that when they put
Yeah.
the date of the date of their decision, I think their software goes back 5 days. And
Could be.
Hey, now you're really recording me now.
That's gonna be edited out.
You know, I don't care. I step back.
I'm in with you, remember?
If you are in the MPN and they say to fax it, you gotta fax it. Because if you don't, you start playing games with them, they're gonna kick you out of the MPN. If you're not in the MPN, never fax it. You want it by mail, addressed to the adjuster, okay? And it's gonna sit in the mailroom for 5 or 6 days. It's gonna sit on the adjuster's desk with a pile of stuff like this another 5 or 6 days until she gets it to, or he gets it to, the UR department. And there's a much stronger likelihood on those cases that it won't be timely.
Send it by
So it's extremely important to do that.
mail.
So I have to get going. Is there any questions?
If you're not in
Not about
mail,
IM.
send it by mail.
I have a question regarding specialty. Now, a lot of, when I'm trying to get internal psych, whatever it may be, and do it as a MedLegal, they tell me that we prefer if the PTP refers it to us. How do you go about doing that? How should I get specialties?
You are the PTP or you're secondary?
No, I'm the attorney asking the PTP. I need internal on this, and it's psych, I don't have anything.
Okay.
And I try to get him at legal, I don't wanna go to QME, I'm trying to get a MedLegal on it. I don't have a denial.
What's your basis for your MedLegal?
Well, I wanna show you, see this
What's
industrial,
the basis of the MedLegal?
Denied case.
denied case,
You already have a denied case.
right,
The case is denied.
yes.
So if the case is denied, then you're eligible for MedLegal.
So why is it that these doctors want the PTP to refer to them?
But only the treating physician can do a med-legal, not a subspecialty or.
Whoa, 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 whoa.
Secondary
No,
physician
no,
cannot.
no.
What now?
You're absolutely wrong.
Really?
So,
Good.
Secondary treatment.
Okay, then
So you
send it
haven't read
to
everything.
secondary.
You haven't read everything. That's good.
Forget us, send it to secondary.
Disputed medical fact too. So if let's say she's an internist and it goes to her as a secondary treater, okay, so you got a referral from the PTP to her, and she does it, and she does an initial report, not a MedLegal report, you do an initial doctor's first report, okay, as a secondary treater, and it's sent to the insurance company, and they write back saying, we're denying internal. Now you just open the door for you to do a MedLegal report.
what,
As long as the applicant's attorney, Alex, then
Request.
send you a letter
request a MedLegal.
saying, I've received the denial of your body part, do a MedLegal report.
now if I send the application, all body parts denied. With no doctor's report, nothing. Let's say post-term. Can I get MedLegals on all specialties?
It has to be a medical denial. If you have a post-term legal defense,
That's the
you
denied
can't
case.
do
Also-
a med legal on a
Okay,
legal
so how
denial.
about if the orthopedic body part submitted and internal
Denied.
site denied?
Yeah, because you gotta look at 4620, the definition of MedLegal, there's some exceptions in there that if on those particular exceptions, you're not eligible to do a MedLegal. Okay? So, but if it's on, if they say if it's based upon post-term, or the person was not an employee, or a statute of limitation, it doesn't give rise to those three cases.
There's no medical dispute.
No, but I
medical
also
dispute.
get denied because there's no medical, let's say. So that still doesn't open the door for MedLegal. The PTP has to send to a specialty, and then after I get a denial on that body part is when I can go get my MedLegal.
Yes, the PTP can get a MedLegal unless they're raising one of those three issues. If they're just saying we're disputing this as an industrial injury, that's fine. And that PTP gets a MedLegal. Next, RFA, it's gonna be that I want what usually happens, like in our office, we do a 3-month review. Because with the 3-month mark,
I know, she's
we know
asking
that
something
more
else,
likely
Susan.
cases can be denied or compensable consequence issues develop. Person starts with a low back problem, and taking medication, now is having problems with the stomach or sleep problems, or whatever it may be. And so those compensable consequence issues, we send a letter to the PTP. We also send a letter to the insurance company. We usually amend the application at that point in time and add those body
But I
parts.
thought there was a case that
Now,
eliminated
if,
that.
questions to doctors. If it's already, all these body parts, all these specialties are claimed in the application, and you haven't sent for any evaluation, what is an attorney to do? If you're calling and saying, client's calling me, he hasn't seen a psych, he hasn't seen an internist, what do I do? What do you do as an attorney? How do you approach this?
Be careful also as the attorney putting all these body parts in your initial application. Too many attorneys do that. They do a skin and content. As soon as you do a skin and content type of thing, first of all, it affects the reputation of the attorney, it affects the whole field. And don't do it that way. It looks, I'm sorry, but it looks very harsh. You want to put in your initial application the body parts that the person was complaining about, and then develop the compensable consequence issues or claims as they develop. And then add them and amend your applications in that way. A lot of our intake people just want to throw everything in there, just like they want to throw a CT or a specific in every case. You got Benson problems and all that. We have to be very concerned about that.
Okay, so I'm gonna excuse myself.
Thank you very much.
Oh, you're very
Never amend
welcome.
the claim form.
Thank you, Sana.
Oh, you guys
Thank
are
you.
always welcome. If anybody wants the IMR decisions, any of the attorneys, you probably can have all the decisions. For the doctors in the room, we can actually give you specific for your modalities. So I'm my assistant, I'm leaving him behind.
Sorry, Gabriel.
So if you give them the email, we'll just actually email you the decision.
Good.
So that way you can have it for your,
Okay, you
it's
can
all
get it.
searchable, so.
We're gonna turn it
Thank
over.
you.
Alright, thank you guys.
Guys,
Are you leaving?
I have to be leaving also.
Where are you going?
If you have any last minute questions.
Dr. Fong.
right now, is there any last
Yeah, the question was
Thank
very
you very
important
Where are you going?
regarding MedLegal, because my understanding was, based on the last case,
guys.
we knew that MedLegal can be done on every specialty if, let's say, there's an orthopedic and it's denied orthopedic injury or denied psych injury, you can have it to MedLegal reports. Then they said, no, only the treating doctor can do a MedLegal report, include their findings in his report.
A case that was just discussed yesterday was a secondary doctor, well, a person going out for a second opinion on, and trying to get a MedLegal report. They said that the case failed because he didn't go through 4061, 4062, and he could only do that with a PPOD or an AME. The mistake the attorney made, it's the same mistake the attorney made in Escobedo, it happened to be the same attorney, is that if I was going to set it up for a consult or something like that, I would send it up, designate that doctor as a secondary treater. I would have the PTP send it to that person as a secondary treater. Let that person come to the appointment one time and write a treating doctor's first report.
I got it,
And let him dispute it, and then opens the door for a MedLegal.
I got it.
That's the way to do it. It's
Okay.
a simple little thing. In the Escobedo case, the same attorney, when the doctor apportioned 50% of her knee problems to, pre-existing conditions, she worked 26 years at Marshall's, Mrs. Escobedo, happened to hit her knee on a cabinet,
So you,
specific injury, and, all he had to do was file a CT for the 26 years that she worked there, natural progression, because there was no medical evidence to show this woman had any problems with her knees prior to entering into the employment 26 years before. And when that same doctor was cross-examined at a COG convention, when he was on a panel, he said, well, all he had to do, I would have attributed 50% of it to the CT and 50% to the specific.
good.
Just doing it right, guys, crossing your T's and dotting your I's and so on and so forth.
Thank you very much.
Thank you, guys. You all have my email, barry@hinton.net, or whatever it is, and if you have any additional questions or whatever, just feel free to do that.
Can I call you?
Thank you.
I like it.
And most of you know that if you need me to come to your office, Michael,
Yes.
Dr. Mary, I've done it a number of times. This
Yeah.
week I'm going to another office, so, okay.
I want to come to your office.
Come to my office anytime.
Okay, let's do it.
Okay, Lance has a great presentation, and he's one of the brightest on how to collect, how to do all this stuff, what you really need to do, what you need to how to lay it out to the report and all that stuff. But the bottom line is, any agreements that you have with an adjuster, you confirm in writing. It has to be in writing. You want that paper trail. The biggest problem I see with lien claimants is they get to court and they don't have justification in their files for the reason to collect. And the only way you can get that justification is having that paper trail. And making sure, the attorneys, even though defense says we'll serve the CNRs, okay, you may not have even filed a lien yet. You don't have to file the lien right away. You may not even be on the address record for the court.
For how long?
And the only obligation that attorney has is to serve.
Yeah, that's right.
We don't want to file a lien. It's $150 to file a lien, so we'll wait until the last moment. Hopefully they'll pay without filing a lien.
Yes, okay, that's a good idea, Michael, but the problem is you don't get a copy of the CNR from the defense attorney or any notices of the hearings.
No, we do
because you're
file
not
after
on record.
18 months, and
No,
CNR
so
usually
no.
does.
So what happens, make sure the applicant's attorney, when you take a case from an applicant's attorney, just have them understand, please make sure, irrespective of who's supposed to do the serving, you send us a copy of the CNR. And last thing, stop being wusses, okay? If you don't like something in the CNR, and you weren't there and you're not a signator of that CNR, I don't care if you tick off the applicant's attorney, object to it.
That's what we do.
You can
I
object to
objected
it.
to you many times.
You can file. You can file
Nobody
your
listen, that's the problem.
whatever it is. Object to it, because, I mean, that's important, because, you know, otherwise, you know, you fail to object to it
He does.
after you're served, and you're stuck with it.
Yeah.
Okay.
To echo what Barry's been preaching and professing for the better part of a decade, it all comes down to the paper trail. Without documentation to establish the rights of the injured worker to treat with his self-selected treater or with treaters within the NPN in a certain situation where they're in the body part that you can't escape, there needs to be documentation to establish those legal facts. So without the start of the process, including the documentation, and there's a panel decision within the last 6 months that talks about the importance, when a case gets to the board, of people having documented the dates of correspondences and communications. So we're all on the paper trail somewhere. The only question is where all of us are, and whether we're making the trail or whether we're trying to follow the trail down. So how many people in the room today are from medical practices? Yeah, I know that one. And how many people are from law offices? Wonderful. And how many people are in the wrong room? I knew you were. So it is the intake of a case. We get the information into our offices on the legal side from the representative who did the intake analysis and intake interview. At that juncture, also, that intake information should be transmitted to the medical office. So now we have a situation where we have both parties to the applicant's representation for the proposition that a failure on behalf of the carrier would allow an injured worker to self-procure. This in-bank decision is similar to the Kuntz in-bank decision on valuation of surgery centers back in 2004. The analysis that the board put into the Knight decision stood and held for the better part of 8 or 9 years until the board started feeling the pressures post 863, and then they come along and say, well, that's not what we meant in Knight. It's not just the notice, the lack of notice that creates the failure. Knight was the case whereby they established the regulatory requirement that the carriers provide all of the notification elements in 976712, which is the list of all of the rights the injured worker has within the NPN process have to be noticed to the injured worker. So for that extended period of time, everyone was litigating under the concept that that failure of the notice was the route out of the NPN. And they ruled for oh so many years that that deficiency led to the ability to escape or to obtain self-procured medical treatment. Then along comes 863, and the winds of the political pressures change, and the panels come out and say, well, no, it's not just, if you go back and read our decision closer, it talks about if the failure in notice leads to a denial of medical care. So the focus shifted off of whether there was regulatory compliance with the various stages of notice at the time of hire, at the time of the establishment of the NPN, at the time of injury, at the time of the change of an NPN. All those various stages were rendered virtually meaningless, unless you can establish, as the representative of the injured worker at that stage of a case, or as a representative of a medical provider 4.5 years down the road, that whatever these deficiencies you are trying to prove up based on the paper trail, this you'd be looking at the defendant's paper trail, led to a denial of the medical care. If that linkage is not created, there have been numerous, more than 20 panel decisions since January 2nd, 2013, where trial judges have granted the injured worker the right to treat outside the NPN. And oddly enough, a lot of them are Southern California cases. And the case gets to the appeals board, and the appeals board goes, oh yeah, the notices were not correct, but you didn't establish that it led to a denial of medical care. So you're not out of the NPN. Reversed, remanded, goodbye. So they were clear, and continue to be clear to this day, that there has to be establishment of the denial of medical care. So we, as practitioners for years, were focused on that narrow-casted 97-67-12 requirement. They now look back on it, I believe, as it was a, they've referred to it as litigation tactics, they've referred to it as a gotcha game, but these are regulatory requirements that were established by the DWC in their promulgation of the regulations. But so they went back and read what they wrote and said, oh, right here we talk about it's only if it led, and in the Knight case it did lead to the denial of medical care, then you have to establish the right to move your treatment outside of the NPN. So as 863 came along, they tried to address that by the amendment to 4616.3. They were hoping to end virtually all litigation on this issue. So into 4616.3b went the proviso that unless it is shown that the failure to provide notice resulted in the denial of care, this was specifically aimed at the litigation centered around the posting notices. Labor Code Section 3550 sets forth the requirement that all employers post the workers' compensation rights in a conspicuous place usually visited by the employees at the work site. So there had been, when this regulatory creation that became 863 was fomenting in the CHSWC, there were a series of cases by where the injured workers were allowed to treat outside the NPN because they were showing a failure of the posting of 3550, the big poster. And the focus was then shifting to the failures of this posting. In fact, at that time, there existed regulatory authority which had been amended within the last 3 years before 863 to say that the absence of that posting, which then required the name of the NPN contact on the 3550 posting, that until that was cured, the injured worker could not have to treat within the NPN. So they sought to end this pursuit by virtue of their narrow-casted amendment to the statute. So they were somewhat successful. The board was already interpreting Knight to say you have to show the failure, and so their perspective, those who promulgated and then turned into the statute, were of the narrow-cast vision that the only failures that the employers, the carriers would ever have were this gotcha that existed as to the notices and that devilish posting. So they specifically cited 3550 within the statute. So we all come to January 2013. 863 is passed. Many of us are in San Diego at the COG convention, and the passionate Tom Martin says, you know what? It was one of the panels assessing the changes within the statutes. It's interesting that they didn't make any mention of Section 3551. 3551 is the more specific requirement that the rights of the injured worker to workers' compensation benefits be communicated to the injured worker at the time of hire or at the time of his first paycheck in writing. So Tom posited, what's to keep anyone from prevailing on the 3551 notice failure? We flash forward a year after that, and we're prevailing on the lack of the 3551 posting, not posting the proviso, the written notifications. So, in essence, the failure, those who failed to post most certainly failed to communicate, but the lack of legislative reflection on the amendments that were rushed through allowed them to narrow their focus on just the written posting. So then we move into 863 and the way the board starts to apply it. One of the things that happened in the same time frame is the Valdez decision is granted, and the opinion issued by the Supreme Court. This was the case I'm sure Charles is intimately familiar with, where they were trying to use the provisions of 4616.6 as a exclusionary rule for the prohibition of the admission of anybody's medical reports that were not within the medical provider network. So they tried to legislate around the edge of Valdez to say that absent that 3550, you had to show that there was a neglect or a refusal to provide the medical treatment. So they were attempting to subvert the remaining abilities to litigate the NPN issue. But yet, while they focused on 4616.12, a short view of the Valdez decision, they failed to notice that there were a variety of other requirements that the carriers have to comply with to ensure the injured worker knows those workers' compensation rights. These have not changed. These existed before night, these existed after night, they existed before Valdez, and they exist today, where these requirements are still there. Time of hire, NPN change, injury date, the 3550 or 51 workers' compensation rights information, and the list of the NPN doctors. But yet, today, as it's been interpreted by every workers' compensation appeals board panel that has sat in San Francisco, is the circumstance of, so what? Show me where it denies care of the injured worker. So we all, going out of the gate as we open a case, we've now received the intake information. We've, on certain cases, it seemed problematic either to the medical side or the legal side. I've had conversations with the offices that we deal with, and we now look and go, all right, the case has now begun. If you get a case in your office where the injured worker either reveals to the historian on the medical side or to your intake that there has been treatment through what they perceive to be the company clinic, which appears to them to be U.S. Health worse or worse, and that is found to be NPN treatment, you now have a challenge as to how that case will be compensable and treatable in a self-procured fashion. Because you're now looking at whether everything on that list was wrong. In fact, there was a case most recently where one of the providers had not prevailed at trial, and then they hired the excellent efforts of Mr. Dennis Thomas from Orange County to file a writ on their behalf, because the carrier in that case had not served the injured worker with his workers' compensation rights and the NPN notifications in Spanish. He spoke Spanish. He spoke only Spanish. This is the converse case to an appellate court case about 4 or 5 years ago called Kraus, where someone ill-advised pursued the issue of notifications in 2 languages, their position being that if you didn't serve Spanish language notices to a person named Kraus, who didn't speak Spanish, then you failed. It was writ denied. But in the current situation, with the provider's case where the Spanish notices weren't served and he did not speak any language but Spanish, he was able to get to the company's language. They were able to provide him treatment within the network. They did not focus in that case on whether that failure of communication in his native language led to subsequent rights he was denied of, but writ denied. He was able to get treatment, so therefore whether it was given to him in his native language or not, it did not preclude the carrier from fulfilling their right to provide the medical treatment. So they continue to make the challenge focused on whether there's been a denial of care. So now we all look at the cases, we see there has or has not been the provision of medical treatment, and we say to ourselves, what do we do? Well, there's no standard approach to every case these days. Donald Rumsfeld summed it up most eloquently, he didn't even know it. There are these things that are known knowns, where we know what we know based on our intake, applying this logic to the workers' compensation case. There are things we know. We get told by the injured worker, they may give us copies of documentation. They go to the clinic, they give a history, It may or may not be the exacting history we received. Maybe they remember another sheet of paper and take it to the medical clinic and say, wow, that could be a problem. Then we move along, but these are the things that we know. But then there are the known unknowns, which is every workers' compensation case in the beginning in regards to medical treatment. There are things that we now know we don't know. In that juncture of the case, we, taking the intake for the legal office, don't know if there's been notice in most cases or not. We don't know whether there's been a signed acknowledgement of the existence of the NPN, which is many defense firms' favorite little exhibit. We don't know reliably whether the treatment they received was NPN treatment or not. So then we move into the last phase of the things that are the unknown unknowns. They're the things that we don't know. So invariably, within a short time frame after the start of the case, and it was more prevalent in early to mid 2013 as it was the new issue du jour, you'll receive a DOR from a defense firm or from a carrier directly seeking to enforce the NPN. Whether it's in an expedited fashion or through the traditional MSC, they file a DOR saying, we're going to enforce the NPN. That date and time, we don't know what they know because we requested all this documentation, but rarely does it get served upon us timely to the request. So you're then left to determine whether you have the predicate facts and the documentation to establish in today's measure whether there's been a denial of care. Not whether he did or didn't get the notice, or he did or didn't have it given to him in Spanish, which now seems rhetorical. But how did it lead to the denial of care? The board saw many cases in early 2013 that led to the new measure of until you show me where the denial was, I'm not too interested in these claims notice failures. We litigated cases on numerous occasions and have our paper trail. Our paper trail that starts at day one, asking for the NPN documentation, asking for the provisions of the rights, have they been fulfilled? Don't get served on. So we, in our office, in that time frame, started looking at the way the decisions were coming out and said, okay, we need to put in additional steps because the carriers and those who regulated on their behalf were of the perspective that this was their only weak spot. This was where their nadir was. That 9767 12 notice and that posting, that's all that's tripping us up. The more you try to use the NPN, as all of you who do know, the worse it gets. We can get into the urban legends of the dead doctors and names on the list that are not still in practice. Those exist. But more importantly, anytime you ask the NPN to take an affirmative action, they rarely get it done. So in 863, one of the other benefits that they added to the system for the treatment of the injured worker was we're going to create this position called the NPN Medical Assistant, an access coordinator, so that if there's ever a problem with the NPN, you call that individual, that number, and initially in the early stages of the regulation, it was to be an entire separate person, a brand new hire, that this was what they were going to do. The regulatory period lasts over the course of the year, it gets watered down. Let's just say it's the adjuster, but they just write the notes down on a different pad. So the NPN Access Coordinator literally turned into the adjuster under a different title, and the obligation is for them to respond within 24 hours. Anybody who was here Thursday afternoon heard Fran Sperani and Diana Sperani go on about the reality of that doesn't happen. So we started working toward establishing the failure, not back with the notices, not back with he signed an acknowledgement. Try to get the injured worker care in the NPN. Make the affirmative call to the NPN Access Coordinator. We have not received a call back in 24 hours on any case we've ever made a call. We send them written requests for doctors from their list to establish NPN treatment. On occasion, we'll get a response 3 weeks later, 4 weeks later. We'll take the affirmative act of trying to work with the medical office to obtain that treatment. We won't give you the treatment unless we have an authorization. we won't respond to you, or when you set an appointment, you didn't know about it, we'll cancel. These actions are the ones the board is now focused on. Since 2015 now ends, over the last 12 months, they've had a variety of decisions that have focused upon those failures, the physical failures. No longer is the notice alone, as established by 863 changes, sufficient to establish an applicant's right. So what's the burden of proof? Who's got the burden of proof on which aspect of the NPN, and how do you fulfill it? Because notices alone are no longer it. So we take the affirmative action in a situation, specifically as Barry points out, everyone was of the mindset for years that under a denied case, or a case that was not yet compensable, that they had no obligation. If they have an NPN, their obligation starts the day they receive the claim form, and under 9767.6C, they have to provide treatment, irrespective of whether they've admitted it, disputed it, delayed it, they have to provide that treatment. So their burden is to show the affirmative act of providing the treatment. Our burden, as representatives of the injured worker, is to establish that's where they fail. So the traditional, long-standing approach of case comes in, you immediately get it to the out-of-network provider and contend there's been failures, but we'll catch you later on those, is wholly ineffective. It leaves the treatment that's being provided to eventually be ruled as having been improperly outside the NPN. So that burden, both sides of the equation have part of the burden, and rarely do each party who's in the rooms where I spend many of my days know what those burdens are. I thought that was Ricky raising his hand. So we have to take affirmative actions to try to show the NPN has not succeeded, the denial of care has been on their lack of action, not on our gotcha by asking for a list or asking for an authorization or asking for a notification of someone's rights. There has to be an affirmative action. In the cases of the past year, they have focused on the affirmative actions and whether they have been successful, and then it's that lack of success. At that stage, they are still issuing decisions and upholding decisions that the injured worker can obtain treatment outside of the NPN. Many of the cases, in fact, it's close to 10 of the cases over the last year, have focused on the concept of the access standards that are in 9767.5. If your treating physician that you seek to acquire within the NPN is a pain management specialist, they still have to be available geographically within the same standard as the family practitioner they wish you would select, or the orthopod that they wish you would select also. In fact, there are numerous cases that spoke to the proposition of which measurement of standard applies. Is it the PTP standard of access under 9767.5A, where it's 15 miles or 30 minutes, or is it the access standard for the specialist, which is 30 miles or 60 minutes? Many of those cases were northern cases, but there were such a significant number of them, and I'm saying almost close to 10 of them. And the board over the past year has dealt with the NPN issues in roughly about 4 to 5 cases a month where they've issued opinions. Many things that just rubber stamp denied that were improper in their reconsideration, or they found the opinions of the judge and the report recommendation to be more convincing. But in the opinions they've issued in that 12-month period, approximately 2 months worth of them have been about access standards. So access standards is a viable route to establishing that the network of the carrier has not met the requirements necessary to provide reasonable medical care to the injured worker. That has been held repeatedly to be a failure of access to reasonable medical treatment. So in the same time period, there are others who continue to try to pursue the staid method of saying there's a failure notice. The Herrera case here, a couple other cases of somebody situated in persuasive panel decisions and no binding authority, speak to the proposition of, well, there was a failure in the notice process. Yeah, until you show the board where the lack of treatment was, or the lack of treatment or the denial of the treatment, how the lack of notice led to that, remanded, denied, treatment found not to be the responsibility of the insurance carrier. So, the path to overcoming this seemingly insurmountable obstacle is not that significant. When you or your representatives from your office enter the hearing room in regards to an NPN issue, if they are as well prepared as you would have them to be, and as well prepared as the doctors available, the bar has lowered on their side to such a level that you literally are there to educate and then prevail. Many times they stipulate to the NPN being invalid or not having provided adequate access to medical care. So, in this juncture, the question that started the path is, which way, how do we get there? When do we need to get there? 5502B was amended with 863. They moved the expedited issue into, excuse me, the NPN issue into the expedited path because it was the concerted opinion of the legislature, the CHSWC, through the legislature, that they wanted these issues resolved because much of the focus in 863 in regards to their version of medical reforms was to eliminate the back in litigation in regards to medical. Evaluation disputes go through IBR. Medical necessity disputes go through IMR. MedLegal now goes through a petition out over here. So if we just get rid of this NPN thing, you'll have virtually no cases left after a case in chief is over. One of the theoretical concepts I can perceive. So they now say, you have an NPN issue, expedite it, let's get to it. So many defendants file that expedited DOR contending that they've got it all locked up and they're ready to proceed. Then they appear and somebody says no, and they don't know what happens next. Their confusion is in the law of the contrapositive. The absence of evidence is not the evidence of absence. So their contention that the ones that are more moderately skilled, I've got notices. I've got signed acknowledgement as an NPN. And they don't understand that the failure of the NPN occurs in more circumstances than not when you ask the NPN to do something. When you ask for any affirmative right from an NPN, it becomes challenging. So on a regular basis, we see the expedited NPN DOR come in. You would be well served by the experienced observation that we've made in our office, and at least one other office I know of. The moment you receive the expedited DOR, call the NPN access coordinator. Ask for an appointment. Ask for an appointment with any doctor they can. Document the phone call. Have your staff member fill out a declaration that they called the NPN access coordinator. This phone number on this date and time. And obviously they won't do the declaration for a day afterwards, and the declaration will conclude, and I didn't hear back from them. Now that alone might not still sway the day. So send a written request for the doctor, and that the appointment be set pursuant to the access standards, 9767-6A. They have the affirmative obligation to make that first appointment. One of the cases that was in Barry's material, we found ourselves with a lot of similarly situated cases, was surely less elect. This was one of the access standard cases where the doctors were not found to be available as timely as required and within the mileage standards that were set forth within the regulations. So when you receive a DOR on the NPN issue, if you are just moderately proactive, you make the call. You send out, in fact, I've given to Ricky, we have a series of 3, I wouldn't even call them paragraphs, 3 letters that have 1 or 2 sentences in them that talks about just the request. You just need a doctor. Sometimes we don't even get specific about which doctor. But if we ask for a doctor by name, they rarely come to the expedited hearing and prove that they provided treatment to the injured worker with the doctor as requested.
Lance?
Yes.
If defendants forgo the 5502 route, do they waive? Or are they stopped from raising MPN further down the line?
That's, well, not, I wouldn't support that analysis during the case in chief. But from a standpoint of post-case litigation, I haven't seen a case come down the board's path yet, but that would be a viable argument, was that they may have waived it because they did not litigate it back in the expedited path as they had the opportunity to, or did not litigate it any time within the case in chief. I would limit that analysis maybe to a post-1113 date of injury, and probably to a case where you could establish spoilage of evidence, or where they don't have or will not provide you documentation that would have been available to the parties in the case in chief back at the time of what would have been a timely expedited hearing. So that's a viable route if we don't get it resolved at the start of the case as the legislature intended by virtue of the amendment to 5502B. The Vasquez case, another panel opinion, showing the lack of performance can lead to the ability to self-procure. In the Vasquez case, they provide the analysis that the defendant doesn't only have to show that these documents exist. Many of them will come to expedited hearings or even regular hearings and you half-inch document. Look at them. Not one of them said they didn't serve on anybody. So this decision speaks to the proposition they have to prove and establish that the injured worker received it. And then secondarily, a bit of dicta toward the end of the case spoke of the proposition of when there's a question about whether a doctor was or was not in the NPN, the affirmative burden is not on the injured worker or the injured worker's medical provider post-case to prove that they were in the NPN. The burden is on the defendant to prove they weren't. They have the obligation to say, okay, you have the network, you have to establish by documentary evidence that that doctor was not in that network. So in this Vasquez case, they didn't reach that burden. Many defendants post-case in chief will try to establish these elements prior to their coming to the new provider's office.
Lance, can you give me any examples of when you've had success in trial and expedited where the judge will give you an FNA or an FNO saying you can't knock out?
Yes, numerous times. In fact, you'll find very few panel decisions out there on the concept because defendants, just as they did post-night, they have reasoned logically that when we lose, just be quiet. Nobody else will really follow up on that. But if we decide we wish to contest the order, that's what was arranged in the evidence order, there would be a myriad of panel decisions on the subject. We prevailed on lack of appointment after providing the call and the letters. That seems to be the most viable path at the present time. Anyone who got to hear the INR yesterday, the treatment open forum, a gentleman who gets up and spoke to the proposition of treatment approved is by utilizing 10101.9 and the series of regulations therein talk about the proposition of bad faith claims administration. Similarly, on the NPN subject, when there's the failure by the carrier to provide the treatment after the NPN access coordinator has been contacted, after the letter has been sent, we sometimes will have to appear back on the same case a second time. And so by the time we have gone that merry-go-round once, we come the next time and start talking about 10101.9 or more specifically 10561 and impress upon the defendant, even if you prevail on the NPN issue, or if we prevail and the board gives it to you on recon or remand that's saying there's no unreasonable denial of treatment, our contention is that your inability to prove up the provision of the notices, the timely establishment of the appointment, and the lack of a call by the NPN access coordinator all three of those are violations of one of 561. So therefore, why would we not be entitled to the cost of these proceedings that you continually invite us to on the concept of you violated every other regulation relevant to the concept, the political pressures of the moment still may give you the decision, but we seek some recompense for the entertainment value that we've been here for. And there are judges that will, limited judges, back to your question, Anthony, is the education process I spoke of a moment ago when they walk in the room, anyone who's moderately trained on the subject and literally knows no less than 4 regulations relevant to the NPM, as Barry noted, you have to educate your judge. The judge believes if they've got notices, I don't want to do a trial. A recent transfer to the LA board from the Van Nuys district office contended it was sanctionable for someone to litigate a limited scope issue where the defendant had stipulated to the failure. She changed her tune before the court reporter showed up.
Lance, can I ask you one question?
2.
When the AA receives a file and through an intake finds out that there has been treatment within a clinic or some sort by the employer,
Yes.
can you request all of the RFAs and the insurance and adjusters or UR's responses to those RFAs within the clinic? And if you find any kind of denial, would that be sufficient to say that there was denial of care?
Well, let's back up to the pronoun. Who are you? Not you. I mean, who are, when you say...
If the AA receives the file and requests that.
Okay, so active case, if the
Yeah.
applicant attorney receives the file, we routinely make those requests, and now I go back to the Rumsfeld. Nobody's giving it to you.
Just subpoena it and then use that as.
Oh yeah, you can subpoena it, and the next thing you'll get is a motion to quash containing 9982, the regulation effective this August relevant to copy services, allows them to give you what they want to give you, when they want to give it to you, and if they ever decide to give it to you. But you can, yeah. Whether it's going to be effective, whether it's going to establish that those failings led to the denial of care, I haven't seen one that somebody's been able to circumnavigate that labyrinth, but it's possible. This is an issue that the board and the trial level judges are not enamored with because they see a complexity, as one administrative law judge said, I hate when you appear because you make it more complex than I want it to be. He sees a notice, and your client acknowledges the existence of the NPA. Okay? And then nobody acknowledged the phone call when we asked for the treatment. So, and in fact, most defendants, when they walk in with these files and notices, and so stipulated, don't even bother the court reporter to pick the phone. And then their brain just like rattles because they don't understand that there could be any other failure because most they encounter still focus on, oh, you got documents. Oh, okay, I guess you didn't fail then, did you? Well, you did, but the failure was the more you ask the NPM to do, the less it does. The less it is successful in providing the medical treatment benefit that the injured worker is entitled to. Back in December, there was a oversight hearing by the Labor Committee of the Senate in regards to the concern that will become more apparent in the next several months, that the claims frequency in the Southern California region is inordinately high and statistically unsupportable. And so one of the comments that I made to the senator during the public comment session was, injured workers rarely come to applicant attorney's office, in our experience, saying, I don't think my PV rate's going to be right. I don't think you're going to get it right. Or they don't come going, you know that voucher? I'm concerned about whether that supplemental fund, whether I got the proof of service to get $5,000. No, it's always about, I'm hurting. I need medical treatment. Mr. U.S. Health Works told me I'm good to go with 2 pills. So they come when there's continuing symptomology and the NPN autocrats have turned them off. So at that juncture, when you, as you spoke, R.C., to the concept of there being documentation of medical treatment, that's when you go right at them. Okay, you've got NPN control at this moment in time. Dr. Kildare, Dr. Boombots, Dr. Bombay, whoever he was paid to say, I don't know anything more about you than the pills I'm supposed to give you, and we're done, you immediately call and ask for another doctor. They don't get it done with regularity. So then we move on to the Ramirez case. The Ramirez case merely spoke for the proposition that an injured worker was not allowed to exit the NPN for the sole reason that the carrier didn't make just the initial appointment. And in this case, again, they talked about it was unclear that it may not have been a serious effort on behalf of the applicant to comply with the NPN regulations, and it was more of a strategy to try to get out. So to contend that one failure alone, they're more comfortable now in granting people outside of the NPN in two circumstances. One, if you're up north, because they don't believe there's a competitive pressure to treat outside the NPN up north, which they've been corrected about. And secondarily, if you give them multiple factual failings that you document with the paper trail, you need to have the declaration of the phone call. You need to have the letters, that just one sentence letter asking for appointment with Dr. Kildare, pursuant to 9792.6 and 9792.5 F or G. And those two affirmative acts right now have proven more successful in any of the any of the NPN litigation that we have encountered. The challenge becomes more troubling for the medical offices if the NPN issue is not resolved as allowed by 5502B or during the case in chief, as Ms. Bartlett points out, because then they are left to try to litigate an NPN issue with a defendant who is allowed to go to trial without necessarily knowing about it. The number of medical offices I hear from on a routine basis that are not allowed service of information by a judge is sobering. It is a challenging circumstance to litigate this issue simply enough during the case in chief, but when you are post case in chief resolution trying to have one of your representatives on behalf of a doctor or your doctor's office's representatives to litigate this issue without having that paper trail that existed for the parties in the case in chief had, it becomes exceedingly daunting and almost a hill too big to climb. So that access standard is one of the big issues. Additionally, the pre-designation is one of the issues. In fact, I was speaking with Ricky on it briefly yesterday. One thing that we found, and varies the issue of having an educated judge, sometimes it's as much a experience of actively listening to the judge to see what the judge wants to hear. They have a limited knowledge of it, and I say that with all due respect, but you need to effectively figure out what they want to hear, where they like the failing to be. And so, back to Tom Martin, January 2013, and the amended statute. I roll upon them, and I have a checklist in my head that I go through with every one of them. I walk in, I say, where are the steps initiated? That immediately indicates to them, he's not looking to transfer in. And then their response usually is, you're not going to transfer in? No, we don't have the facts for that right now, but I'll talk to the client about it later. So they, invariably, I'll say, do you have the 3551 rights notification package? What? I thought so. So most of them don't know that it's existent or it's factual and legal meaning to be in the end. In the 3551 package that was amended early last year by the administrative director, that pre-designation form is now part of the package. So if somebody was not given their 3551 written rights, and they cannot prove that they were allowed to pre-designate, we have prevailed, and it is our concerted contention that if you have not been allowed to pre-designate, what would keep you from pre-designating right now? And if you did not allow the injured worker the right to pre-designate, how do all your affirmative NPN rights arise? Now, if you recall, 3550, 3551 have proven effective against the statute of limitations defense. So how it can't be effective against an NPN defense, for lack of a better word, it's incongruous to think that it would not overcome such a limited aspect of the case. But so we start by pushing on, where's the pre-designation? Did you give it to him or did you not? Whether you acknowledge the NPN, that's all great. But did you give him the written opportunity to pre-designate his doctor? Because chances are, he probably would have done it. And more than one defense attorney has run to the phone and come back and go, okay, they appreciate it. Because in essence, I'm pushing a legal fiction at that point that a pre-designation at this moment in time would allow somebody out of the NPN completely, which is not truly the legal measure. But if the other legal measure knows less about it than you do, you're okay for the moment. So every one of these elements to this NPN compliance proves effective. The only question is who it proves effective on and what part of the case it proves to be most effective. Every judge wants to hear something different. They, I'm sure, have in the corner of their head the last decision they wrote that nobody contested, that they liked how it ended, and I want to try to go that path because I've already got the decision written. So listening to what a judge is asking, once you can turn him on to the defendant after he's getting off of you, is the first step. There's one judge at the Van Nuys district office, and then he has the parties in, he looks at the defense attorney and says, what's the name of your NPN? Especially if it's out Berkshire. Berkshire for Oak River, for Oak Fire and Trust. Many people that appear for the defendants, legally, some of them don't even know who their true client usually is. But then more specifically, they don't know the name of the NPN they're there for. And so that's his pet issue. So I just let him go. And he breaks 2 out of every 7 of them on that issue by itself. You don't have to go any further because that's his methodology to educate them that you don't know what you don't know. And so why don't we stop now as opposed to make me work harder against your issue. So it is that has proven most effective, is listening to what the judge want to hear. Once you have them listening to the concept, and it's different in every district office. The NPN issue is not well received in the arena. Not an issue they see a lot. In the Inland Empire, it's not one that's too successful because the practitioners there have limited treatment options in certain circumstances, and so they're not always as aggressive of trying to get the injured worker self-procured treatment. It could be to the improved condition of the outcome of the case. So that path of listening, especially if you appear with unrefuted NPN access coordinator call. In fact, there's a trier of fact on the 9th floor at 320 West 4th Street that thinks that it's a legal requirement that you make that call. And oddly enough, that's what led us to start doing it, is once you show someone a declaration that they made the call, a written letter asking for the treatment, he's in a corner and has to look at the defendant and go, why didn't you do it? And invariably they go, I didn't get it. And I go, we didn't mail it to you at home either. I'm not interested in you. They don't have a response at that point. This has nothing any longer to do with the 976712 list, even the night analysis up to the point of denial of care. It's now about the formative denial of care that happens after the next affirmative act on behalf of the injured worker to change treatment within the NPN. Yes, oh, you're providing great NPN treatment for the doctor, probably. And now we want to pick doctor number 2. You didn't let us get doctor number 2. And so they are finding and holding that when they have something that the commissioners can get their hands around in regards to there's a physical denial. This is not somebody who was just trying to sit back and bury it in their case opening letter and then say, oh, because I don't think you got the NPN right, I'm going to designate my treater in the same letter. This is not that. This is now someone has put in the physical manpower hours to call the NPN access coordinator. They never answer the phone either. And then send the letter, and then you just set them back and wait for the expediter. Because you now have only 2 exhibits, and what they walk in with will not even comply had they acted on your calls the day you made them. So, back to your question, RC, is it varies with the judge, and it's what you get them to listen to. If the goal truly is to support the self-procured treatment and those willing to provide it, because absent that in the medium or long term, there'll be lesser and lesser of those willing to continue that path. And so the proactive step of making the call to try to get it established that there was a failure on behalf of the carrier after the notices, after the U.S. Health Work visit, that's where the board's focus is now. They like cases where they can affirmatively show that the carrier, a omission or lack of an action on their part led to a denial of care. There's even a recent panel decision that spoke to the proposition that we've been trying to get their focus on for 4 years, that providing somebody a list that says Coventry, U.S. Health Works is not sufficient to identify to the injured worker who those doctors are. And so in that case, it was dicta, but the analysis held that you need to provide a sufficient list of the names of the doctors.
Lance, so a doctor's office, even if they're outside the MPN and they know this is going down the MPN route, they can have and they're willing to take on that risk, they can have their the patient, maybe with the staff, make that call to the MPN coordinator if they don't have an applicant attorney that's doing that.
Correct.
And do that whole process internally, maybe document it in their report.
That would not be the worst thing they ever did for themselves, because there's no requirement for that call to be made by the legal representative of the injured worker. So if I was in the shoes of a practitioner and had not received any substantive response to my calls to the law office, which can happen on a irregular basis, I would look at the injured worker and say, oh, you were treating with Dr. X in the MPN, based on what you just brought me, the history of the legal officer didn't pass along to me. How about we call them right now and ask for that? Because then the practitioners themselves are documenting that failure, even in the absence of the paper trail being provided to them. And that would be a proactive step. The sending of the letter requesting it might be a little more challenging, because it's very noted, relevant to an injured worker signing off on a request from MedLegal, is a judge or commissioner is going to look at and go, oh, the injured worker themselves is requesting a doctor. There's no authority that says they cannot, but it may be looked upon as if it was a self-serving gesture only intended to do what was right, which was document the failure. But back to your question about provider's office. David Parris' case from 2 years ago spoke to the proposition in Commissioner Kaplane's opinion that you are allowed to treat disputed body parts outside of the network, even in an admitted case where the MPN is found to be compelled and appropriate. So it's not a circumstance where any treatment relevant to disputed body parts is the sole province of the MPN providers. If they are not providing that treatment to your injured worker, you would have an unhappy client if you don't try to address those aspects of their claim of injury that are causing them ongoing symptomology. Referrals by NPN treaters are so few and far between. I can't remember visually having seen many of significant. But so the ability to still provide for the disputed body systems with a confidence that there's going to be a reimbursement opportunity is a good thing. But proactively taking that step that RC speaks of about making that call yourselves from your medical offices would not be the worst thing you ever did for yourself in the current environment. So, any perspectives or any experiences that anyone here has had that leads to a positive outcome? Today is the day to share, to bring those perspectives. Before we talk about Ileana's and Lulu, this is my favorite case of the moment. Anybody have any experiences with notifications that have proven successful? Sorry, what was that one? No, there's any circumstances where you've used the lack of the carrier's notification to succeed at the ability of documenting the applicant's ability to prove outside.
Have we attempted it?
Have you succeeded?
Oh, attempted, yeah, succeeded, no.
Oh, the attempt is almost as important as the outcome, because that starts the process. And if that is the first step, and there will be times where you won't be able to establish that documentation of a carrier's affirmative failures if the expedited sneaks up on you. Say you don't know about the expedited DOR until somebody hands you your calendar and goes, oh wow, look, that's Tuesday. Today's Monday. You won't get there. But if you can limit the liability or limit the finality of the issue on that expedited that you go to, as you speak to that lack of success based on what you had the first time, you may be able to leverage that into documenting their failure next. Because what, with the hypothetical I described, what I would do facing that circumstance if I didn't see the bullet coming before it was on me is, as RC talked about in the doctor's office, if I had the applicant in a hearing, okay, today's the day we're going to pick. Make the call right then, document it. Make the request as soon as your office can get the one-line letter out. Odds are greater than 3 to 2, they won't get it done. And so then you're left to come back the next time and then you have established your own evidence, whether it was pre-existing in your file before, that we again tried to comply and cooperate, and we were without benefit from the NPN system. I speak of the Liliana Ben Lulu case. An interesting case because it goes back to their latest approaches of their defense perspective is, irrespective of what we've done in the past, if we want to transfer you in, we're good to go. So, this case comes to us from the Marina District Office, and Ms. Ben Lulu had been treating for years, numerous years. And the defendant had repeatedly tried to transfer into the NPN. Repeatedly, their evidence of this attempt for the transfer was insufficient. It was unclear based on only reading the panel opinion whether they had litigated the issue previously. Without a doubt that was the case post-2013. Because the object lesson of this case is that if you allow those failures to exist and you don't affirmatively push the issue, there is a chance they will get a successful transfer of care on you, because in the Ben Lulu case, as the board went through every failing of the defendant, they got to the last one and they got it right. The notices were correct. They had corrected the deficiencies in the 97, 67, 12 rights notification. The transfer letter was correct. It wasn't one of the 4 conditions to warrant staying outside of the NPN. There was no responsive report from a doctor trying to establish one of those 4 conditions. And so the transfer in was then held successful. So the short takeaway is that if you see a failing and you think you have the documentation to establish it, you may be better served taking the affirmative act of litigating the issue on your terms, taking the issue toward the defendant, as opposed to waiting for them to transfer in that they can then establish was correct. Because until that issue is litigated to conclusion, as we saw in 4603.2A2, the defendant can bring the issue at any time. But if they bring the issue and there is a finding that they were not compliant, sufficient to lead to a denial of care, they are precluded for the remainder of the case for interrupting the applicant's right to treat outside the NPN based on the existing opinion. So sitting back and waiting for a defendant to push an issue may not always result in the peace in our time. So this trial checklist, while denominated a lien trial checklist, is accurate for the case in chief phase of the case as well. I spoke earlier about I have this list in my head. That's basically the list. It talks about I want to go back and see in the NPN intake questionnaire whether there was treatment before the initial visit with the self-procured treater. because that in and of itself, absent an affirmative move to establish a later defect, would render that evidence sufficient enough to establish their right to medical control and preclude reimbursement up to that point in the case. Applicants on occasion will have NPN correspondences that they haven't always shared with you, not out of any nefarious desire, but they're myriads of correspondences that they're not usually used to receiving, and so therefore they receive so many of them that they don't understand the legal import of their meaning. So that checklist 3550, the timeliness of the appointment, whether the carrier made the appointment for the injured worker, all together will allow you to analyze whether you have the records sufficient enough to overcome a defendant who won't agree that they have caused a failing that resulted in a denial of care. So we go back to defendants always think they're right. And the analogous approach in the IMR scenario of using 101.9 and unfair claims practices to get a defendant to accede in that circumstance to a treatment request, in this circumstance to treatment outside of an NPN. They'd be more reticent to do it because that would affect, they view their cost for the remainder of the case, which they look at as being unlimited. But this approach that we now look at is one that has started to bear fruit as well. Every individual, injured worker, and their representatives have a right to file an NPN complaint. The NPN complaint form is available on the DWC website and sets forth just basic information requested to document this failing. Earlier when I spoke of impressing upon defendants that 10561 and costs are going to be an issue in the future, and whether we ever adjudicate it or not, that petition will live on through the case. This approach has proven sobering for some ACMs and adjusters, because with the evidence failing on no greater than, I believe it's 2 or 3 occasions at geographically different locations within their NPN, an NPN complaint found to be factually based on more than those statutory 2 or 3 occasions leads to a petition for suspension and revocation of the medical provider network. So literally, an injured worker's case in a circumstance where a carrier does not fulfill their regulatory obligations, if it is more than twice in one case, and I've seen it more times than I have fingers on one hand in a case, if documented, complaint form filed, they could be facing a petition to suspend or revoke their NPN because of their failings in a case, or as the approach that I've started to view is a series of cases, like Alex speaks to with Berkshire Hathaway. And you see the same defense counsel on a regular basis. Oh, remember this one we talked about over here? I got you over there. Now you got 2 of them. You know what the regulation says? It says more than 2 or 3. You might ask your adjuster, is this one they want to be the one that puts them over the edge? There's no certainty the administrative director would follow through with the processes outlined in the mere forms, since we now debate whether shall means shall or shall means may. Because likewise, as I pointed out to Senator Mendoza at the oversight hearing, when there was much talk about medical costs and untimely UR or not, IMR processes, they have the tools to penalize the UR organizations and the IMR organizations for untimely performance, and to this date have done it with such limited frequency for it not to have hit the radar screen more than once or twice. So this methodology, not at the initial litigation of the issue, but moving toward an NPN complaint and a petition to suspend the NPN, is an attention getter. And it sometimes proves persuasive to the adjuster, the desk level adjuster, or the ACM, that this might be the opponent that we don't really push this issue with today. Maybe we do for another day when somebody just says yes. So now we go backwards for a second. Everything to this juncture has been about litigation, usually within the delay period of the case. Just to backtrack one step to 4622, carriers in the last 6 to 8 months have become so hubris laden and exhibit temerity that's unparalleled. They're now filing DORs in the delay period, saying we have NPN control right now. Why is your person going to Dr. Montgomery's office when we sent him notices that he shouldn't be treated because we have an NPN? And we sent notices to the injured worker. We didn't. So you knew about the claim on day one. When did you send him the first notice about the NPN? 3 weeks later. That's pretty good. Secondarily, do you have the appointment notice was sent to make the appointment for your doctor and your NPN that you have the affirmative burden to do under 9767.6? We have actually had defense now, they've all realized that in that delay period, 9767.6C allows them to control that $10,000, up to $10,000 of treatment under 5402C. And if they can establish that they had that control, then they don't face that liability for that up to $10,000 treatment cost later. Not a one of the insurance carriers that have approached our firm on this issue in the delay period have even had the perseverance to wish to litigate it. 3 of them denied the case on the spot, and the other 2 tried to withdraw their DOR because they were trying to make an affirmative move for cost savings on the medical side to the pre-denial treaters under 5402C. This wasn't a good deal. So now, with the same self-selected providers, we're back to 4622 that Barry spoke of earlier and Charles was insightful on. The ability to capture the revenue on the MedLegal report is one that will arise after that date of denial. The old knee-jerk, old-school approach of MedLegaling everything that comes through the door, or denominating that first massively narrative report as a MedLegal report is ill-advised, not supported by statute, and it would be right on. Because, as noted, 4621 talks about the prohibition of any MedLegal report being authored in the first 60 days. The code goes on to say neither the employer or the employer will have liability for it. As here, it talks about the affirmative burden on the medical offices who do pursue MedLegal, perhaps having the Apex letter requesting the MedLegal report, many of which do not. And the response I heard from some of them on occasions, but hey, we get paid. You may get paid by 1 or 2 along the road who opted to pay as opposed to litigate at that juncture of the case, but be mindful of 2 things if you're in medical practice. Any payment made to you under 4622 is subject to reimbursement. All they have to do is come back later, there's no statute on how long later, and contend that they weren't true MedLegal charges, and somebody will pay them back. Here, post 1113, if you know providers or your office as a medical provider has been doing MedLegal religiously, one best be mindful of this statute change in 4622C. The EORs, many offices have ignored as noise for decades, the ones that have all zeros in them. Don't look at it. That EOR on the MedLegal billing starts the clock. And if there's been no objection to that denial for any reason other than an IBR reason, within that 90 days, neither the employer nor the employee will be liable for that MedLegal charge. And so there are many practitioners to this day, sitting out there knocking out MedLegals like 90 going north, thinking that I'm just going to sit back and wait. I'm going to get paid like $625. They're not as valuable as blank paper because they did not know of the affirmative obligation to object when that EOR came in. They might want to resubmit it for re-review and see if they get somebody sleeping, because the law will never support their reimbursement. On the subject of MedLegal, as Charles spoke on numerous occasions with Sana previously, The Brower decision is the current in-bank decision that speaks for the proposition that MedLegal is payable to a secondary treater, not just to the primary treater, but a secondary treater. Brower, an in-bank decision about a far more complex subject in regards to the TB rate on a 100% 4662 case, but for any defendant who wishes to tell you that it's mere dicta, at page 7 of the Brower decision, page 7 of the printed in-bank decision, it talks about how the defendant neither pointed to any legal authority or any other proposition for their need not to pay the MedLegal back to the injured worker. In this circumstance, the injured worker's attorney, Mr. Art Johnson, who paid for it himself. So that speaks for the proposition that MedLegal, currently under that in-bank decision, with no stare decisis opinion of the greater court contending otherwise, is payable. But it's only payable if you comply with 4622C, and then you can avail yourself of the remedies under 10451.1. So, to summate, it would be safe to say that we all, in regards to working with providers who have taken on cases as a result of desire to market their services, leaves us with a obligation to ensure that our injured workers' rights to those medical benefits of the self-procured treatment and care, extending to that as well, are protected. And anything we can all do as a community in communication with each other, from medical office to legal office on cases where it's the same case, or in circumstances where one of us who represents injured workers on a regular basis sees a new affront from the carriers on the MPN issue. The things that we can do in sharing our perspectives and our methods may better serve and allow those who are taking on the right to self-procure outside of the network, may make them more agreeable to continue that prospect, because absent that, it will be a limited amount of time where they continue to accept cases from even their longest standing legal sources, but yet find themselves with no support for their concern for reimbursement. At the CAA seminar back in October in Los Angeles, one orthopedist said to the collective room of attorneys, what's happened over the past several months is that many smaller orthopedic offices have been closing, who have provided treatment for months or years to injured worker, and now everyone's sending these cases to me. I'm accepting them at the present time. But if I continue not to get support from you, the community, on our ability to document in our paper trail to get reimbursed, I'll probably be the next guy who's leaving. So it's active on the mind of many medical practitioners that a more active support, if not on a daily basis, but just when there's a desire or need for documentation, that vaunted paper trail that Barry speaks of so eloquently, and now the paper trail can be as small as 2 documents. If you have those, if you create those, once you see a defendant making that affirmative move, that case may be a case that provides reimbursement to the self-procured treater who otherwise may have been left without reimbursement on another case, and then calls him to take a risk-reward analysis from a cost-benefit standpoint of whether marketing in the future is something that's in his best interest. So, questions, comments, tips, anything, be more than happy to address them. Yes, ma'am.
What if the applicant attorneys and the provider offices hire an independent source to contract through the AA's office during the case in chief to do the petition work on MedLegal's and enforce the recovery on that on the medical side, but then the applicant attorney gets a benefit from the cost and sanction side?
Well, I'm clear on the specifics of the question. The concept I understand, I think that would be a well-reasoned perspective from a medical provider standpoint, because that speaks to that issue I was talking about being in a regular communication between those types of offices. Because then from the medical side, that would help support the legal practitioner's ability to continue to their managed caseload under the litigation demands it currently has, and not put a undue pressure to litigate the MPN issue solo on themselves over a course of time. And I've seen that done for several years, where a applicant attorney has asked for assistance in regards to an MPN issue. Number one, from the standpoint of the documentation the medical practice has in their file, as well as the availability to have somebody help support in that regard. So I'm sure it would be appreciated on both sides. Whether there would be the concept in regards to anything in regards to unreasonable delay would still accrue to the benefit of the injured worker if there was a 5814 issue raised. 5813 in regards to costs relevant to statutory violation, regulatory violation that we spoke about under 10561. That too, I think, would help offset the cost of that litigation, whether it's through the applicant attorney's office or through the medical provider's assistance. I think it would all be positive. It's just a matter of what the community wants to do. Yes, sir?
I have a question. Can you do a medical report on this post-termination CT claim? Because I understand not, but don't you need to have a doctor say that the applicant suffered an injury, and the applicant first found out he was exposed to industrial injury through a doctor's visit?
I definitely agree with the analysis and the description you give it, but I agree with the guy sitting across from me. In regards to, and this
I
issue.
understand the specific, but I'm talking about CT claim. Because
Right.
technically,
Correct.
when the applicant sees a doctor, the doctor establishes there's CT trauma,
Correct.
notifies the injured worker, this is the first time he's aware of it.
Yep.
So if I don't have a medical legal report, how am I supposed to establish that?
True. I concur with that. The board has seen this issue twice, but it comes up on our radar screen on a regular basis. A defendant has the legal denial that Chuck was describing in regards to post-termination, statute of limitations, initial aggressor, whatever they've got that defense. So some defendants will go as far, not relevant to the MPN issue, but the net legal issue, to cancel a QME evaluation properly obtained and set, and say, oh no, we're going to litigate the legal issue first, because we don't even need that report to play into the determination that we, the defendant, wants to have reached here. The two cases that I've seen over the last 8 or 9 months, the board has come back both times and said, while we understand the perspective of the defendant, two challenges with it. Number one, it's presuming that the history and the opinion of the doctor in the med-legal setting relevant to the credibility of the applicant and mechanism of injury would not somehow allow and add to the judge's analysis of the testimony of the injured worker that would otherwise be unrebutted, absent employer-level testimony or employer-level investigation documentation. So they held in a panel decision that yes, you must allow the 40-60 evaluation to go forward. Now, I agree with Chuck from the standpoint of what is the dispute that could be resolved by the medical report. The diagnostic part of the medical report, I don't think would address any of it, but the question as to history, mechanism, and
knowledge.
Exactly, would be beneficial. We have a tough sleigh at the LA District Office on that front, but a couple of judges are coming around to the concept of the other panel decision that relevantly touched on the issue was as follows. While we understand the defense desire to expedite the litigation, what happens if the judge doesn't find for their factual or legal defense? The injured worker is left now in a proceeding without the statutory right to that med-legal evaluation, 40, 60, and or treat or med-legal, number one, and no one will have established good cause to bifurcate the issue. We don't want AOEC who is bifurcated, was the wrong short takeaway from it. And so, but we see that routinely where they try to push the factual issue saying the medicine's got nothing to do with it. but at least two panels of commissioners are of the mindset that while you may be correct from a medical and diagnostic standpoint, which I support, but it speaks to the issue of there being a corroborating documentation where an applicant has provided that history. And it gives a judge a better perspective on the credibility issue. And then you can just really get some more credibility.
But Lance,
Yes, sir.
for a more practical standpoint, I've seen thousands of denial letters, hundreds of being post-term, and I haven't seen one ever that says just post-term. It always says post-term and lack of medical evidence, yada, yada, yada. So you're always gonna get, Alex, the medical dispute anyway, so.
Right. And if it's not in there, and you have the foresight of seeing that coming, similarly, as I said, approaching the expedited DORs, if you see priority DORs coming in, you'd be well served to try to do two things immediately. Request the 4060 panel if you didn't already do it, because now you'll have it in your hand instantly. Secondarily, you are 3-2, the defendant's going to cancel it. Or they don't say they cancel it, they're going to send a dispute letter to the doctor who says he won't get paid, having not read Contempt of Plum and Commissioner Gaines' opinion from the 70s. Found it to be content to do that. But to get the MedLegal report out of your treater. Because then they won't be able to say, well, we didn't want you to have the panel MedLegal report, so we can't have that MedLegal report. How did you get that one yourself? Because then Brower would appear and say, what's your proposition that I can't have a MedLegal? And if you take that affirmative act, I think when you receive the priority DOR, the beauty with priority DORs is they can continue, and per statute are literally supposed to stay on calendar until the causation dispute is resolved. But traditionally in Southern California, from our experience, the LA board and the other high volume boards, they usually take them off. But it gives the judge the understanding that you were looking to get causation reporting. Because like Chuck said, rarely is there one that just says statute of limitations.
One other thing, our colleague over there was asking about other specialties and how to get there, right?
Right.
Here's what Tom Martin does. If you look at 5502, which says what you go to expedite hearing on, right? One of them is medical legal evaluation. So what he'll do is he'll file a DOR, he'll go to the board and say, I pled internal. They've denied internal, and judge, all I'm asking you to do is I'm asking you to authorize the doctor that I'm going to pick to write a MedLegal to address the dispute. And it works.
That seems highly effective.
What's that?
Because, Chuck, to your point, I'm not sure if anyone's made the claims universe-wide observation, but since October 1st, when the medical unit activated the online request form for the initial QME panels, they are not even issuing additional specialty panels. When you have the report back from the initial QME that says needs psych and needs neuro, you'll send it to them and you'll get a rejection saying, but have you tried to agree with the other one yet? Right. We like that. I mean, it's sobering. Because now with this added amount of time they have on their hands, the medical unit has fashioned themselves a administrative arbiter of issues that they don't have the authority to do. Additionally, to that subject, the 31.5 A9 or 10 request for a replacement panel, a different specialty, Assistant Medical Director Admiral Branch has upped his issuance of high-frequency orthopedic doctors in response to a request to change chiropractic evaluators since October 1st, 2013, with such a frequency, it's surprising. But yeah, Tom's approach to that seems...
And I can just file removal. If that's what Morgan's going to do, I remove her every time. Because it's illegal. It's arbitrary. You might lose it a few times, you get the right panel, and they're going to spank her.
If you get a QME that requests a specialty, and a defense requests a QME for that specialty, you don't agree, you don't cross, can you go get your MedLegal?
I wouldn't view those two circumstances to being mutually exclusive. What's to prevent you from getting MedLegal even if there is a panel? In the Brower case, there was an A&E inside.
No,
There was an AME in psych in that case. So just because there exists a panel in a specialty does not preclude that med-legal treater report from existing. And they actually, in the limited analysis contained in Broward, where they didn't approach 4064, but the limited opinion that they provided was that there stood no proposition, legal or otherwise, for the lack of it being reimbursable. Secondarily, if your defendant is providing resistance on getting that panel, they've got a corollary to a collateral estoppel problem, because I can't say that you can't have that med-legal, but then you can't go get that one either. There has to be a route. And so, from the provider standpoint, I would hope there is a degree of comfort in understanding that if they've seen you have a degree of success in forwarding their interests in making sure that they're communicated with what they need to obtain the reimbursement. Nothing more? Excellent.
Chuck?
Yes. I